Welcome to the Nightly 5 podcast with Ben O'Shea.
I don't accept that it was my job was to cover up crimes, but I would say I just actually did the job I was trained to do.
You just heard David McBride, a former military lawyer who leaked classified documents that revealed allegations Australian soldiers committed war crimes in Afghanistan. Today, McBride was sentenced to spend at least 2 years and 3 months behind bars. Here to help us understand what this all means is Associate Professor at the University of Queensland School of Law, Rebecca Ananian-Welsh. Rebecca, thanks for joining me.
No worries. It's a pleasure.
And so today's sentencing was the end of a long and winding journey for David McBride. Can you take us through what happened in this case and what he was originally charged with?
So David McBride, as you said, spent about 18 months collating classified documents when he was a defence lawyer. So he was a military lawyer, he had access to everything, and he realised that there were potential war crimes being committed by Australian soldiers in Afghanistan. He tried to do something about this internally. He tried to follow the proper channels within the Defence Department. The police felt like this was getting nowhere and that his career was maybe getting nowhere at the same time. And so he decided to give the documents to journalists. So the only reason that we know or got to know years ago that there were potential war crimes being committed by Australian soldiers was because of David McBride, because he spoke out. He was charged because he'd done something wrong. You're not allowed to leak classified documents to journalists, but he should have been able to rely on whistleblower protection laws. It's a complicated, as you said, winding story from that point with years in court, but eventually strategic decisions by the Defence Department, by the government lawyers, meant that he couldn't rely on whistleblower protections. The evidence he needed to do that was secret. He couldn't get access to it. So that avenue was cut off. And without being able to rely on whistleblower protection laws, he had committed offences. He'd shared classified documents. He pleaded guilty, and that's what he was sentenced for today.
And so even though as a result of his leak, there was a subsequent inquiry that did actually find credible information about war crimes allegedly committed by the Australian military in Afghanistan, that didn't vindicate him or really play a part in this criminal case.
No. Look, once his whistleblower case was scuttled, I guess the lawyers and the civil rights advocates were waiting to see whether the judge might exercise some sort of leniency here. What David McBride revealed were really credible evidence of some really bad stuff that was important for us all to know. What's happened today is that the judge has said what I'm giving more weight to isn't the public interest in finding out, it's the fact that he did things he knew were wrong. He shared secret documents, and that's not okay, and he did it secretively and he gave it to journalists. So it sends a really bad message to people who might be thinking of calling out wrongdoing that they can see.
Yeah, the message, I think, from this verdict and sentencing is pretty clear. But in terms of legal precedent, you talk about public interest and you've mentioned whistleblower protections. What does this guilty verdict for McBride mean in terms of those protections?
The protections themselves, so there are problems with whistleblower laws, and myself and other kind of academics and law nerds will pick over them, but the protections are there and they're relatively robust. We have decent protections. If you are calling out wrongdoing, then there are laws that should protect you from any kind of repercussion, be that losing your job or a criminal offence. What happened with McBride is that decisions made along the way were throwing up every obstacle possible to him even trying to rely on those laws. So it wasn't so much a problem with the laws, but this policy by government to not even let him try to establish that he was a whistleblower in court. So that says even if you are a whistleblower, we will do everything that we can to prosecute you and make sure you're punished for revealing secrets. That's really disturbing.
Yeah, it does seem as though the government moved the goalposts a little bit when it comes to the McBride case. And now, I guess, will he appeal? Is that an option?
I believe he is intending to appeal. And when you're talking about things like the public interest and the interests of democracy and transparency versus national security, I think what we're seeing is that that's a really hard balance, and it could go any way. So these are more policy kind of decisions than legal ones, but the court is having to make a call. What we were fighting for, what I think should have happened here, is for the government to step in a lot earlier and say, we don't prosecute whistleblowers, which is what they did for Bernard Collaery, and now recently saying with Assange, we're not going to support the prosecution of whistleblowers. We're going to kind of accept they've done something good for democracy, protect them, because what they revealed was actually worse than what they did.
Yeah, I think there's a very good argument for that being the case. From the University of Queensland School of Law, Associate Professor Rebecca Ananian Welsh, thanks for joining us and sharing these insights on the Nightly Five.
Thanks.